Sorry for the delay, folks. Just 1 second here. All right. Okay. Apologies for the delay. I was trying to find a nice picture, but I couldn't find it. Okay. Well, welcome back. Sorry for the delay in getting going here. Okay, so I hope everyone had a nice weekend. Today, I had a couple great conversations yesterday at office hours. Those conversations and your emails have led me to think that the cookie is half-baked, like you're getting parts of it, but it's still possibly raw inside. So we're going to try to fully bake the cookie today. And so I'm just going to kind of reiterate where we are before we move to the new material. Today we're just going to somewhat review what we've been talking about, apply this framework to cybersecurity disclosure, and talk about how you might apply the material we learned last week on materiality to an exam question, let's say. And I think that might be a useful way to kind of make sure that everything is, in fact, as baked as it can be. Okay, so let's just remember how we got here and where we are. So we said that under the 1933 and 34 Act, there are only affirmative disclosure burdens as prescribed by the statute, first and foremost, and thereafter by rules that have been promulgated pursuant to specific statutes. And so we said there is no general duty to disclose material information. In fact, there is no general duty to disclose information in general of any kind. Instead, we have specific obligations of disclosure that are found in various places in the securities laws. So we're starting this conversation, if you were thinking like, where are we in the grand chapter of SecReg? Well, we're starting with Form 8K, Form 10K, Form 10Q, Form S1, the new issue registration statement for IPOs. All of those, if you remember, when it came to qualitative disclosure, when it came to non-numerical information, they all pointed to a particular regulation. Who remembers? It starts with an S. SK, right. They all pointed to Reg SK. They all said, to know what to say, you need to look at Reg SK. So we might be on a part of, the S1 or the S3 that talks about your business, and the instructions I'm not going to show you again, but you remember from last week, the instructions will say, go to item, fill in the blank here from item 101 of Reg SK. That is a regulation promulgated pursuant to a statute. It has the force of law. It is found in the Code of Federal Regulations at the citation that is listed on the form. Okay, so we are in fact in law school, believe it or not, and we are in fact learning that there are, laws, statutes, and regulations, and Reg SK is a regulation promulgated pursuant to the SEC statutory authority. Okay, now when we look at item 101 or any item under Reg SK, what do we find? We find specific, not general material disclosure rule, but specific instructions about specific items that must be disclosed, specific facts about the company. And as is often the case, as I showed you in the text last week, generally speaking, many of those items will have materiality qualifiers. Not all of them. Some do not have materiality qualifiers. But the vast majority of mandatory disclosure rules under the securities laws that we have, in fact, are qualified by materiality. That is, disclose material assets, material plans, Okay, nod your heads if you're all with me so far. Okay, so then we said, so you are the faithful securities lawyer filling out Form S1 or Form 8K or Form 10K on behalf of a client. Client asks you, what do we need to tell our investors? You say, well, that's easy. Let's just look at the instructions to the form. The instructions to the form point you to Reg SK. You open up Reg SK. You have a paragraph that is qualified by materiality, and your client says, what does that mean? And you say what? What do you say? Well, like a good lawyer, you go to the case law, and you find that materiality was defined in the Texas Gulf sulfur case. And you say to your client, it turns out that we need to disclose information facts that reach above some threshold that is characterized by this two-part test that the majority articulated, this probability and magnitude test. And your client says, great, what do I disclose? And you say, well, that's really easy. It's a two-part test. You just read the majority opinion of Texas Gulf, and you'll know exactly what to disclose, because the information has to be of a basic, what's some of the quotes from Texas Gulf? It has to be of incredible importance to, come on, someone give me a quote from, what are you going to tell your client? You're going to tell your client, you only need to disclose those situations, as we read on page, 16 of the PDF, those situations which are essentially extraordinary in nature and which are reasonably certain to have a substantial effect on the market price of your security. And your client says, that's fantastic. What does that mean? Like, do I need to tell them about my upcoming product? Do we need to tell them that the CEO's uncle has cancer? Do we need to tell them that we're thinking about possibly, expanding our business operations into a new geographic market? And you say, well, whether or not you're going to have to disclose those facts depend on a balancing of both the indicated probability that the event will occur. You read off an excited young lawyer to your client, and the anticipated magnitude of the event in light of the totality of your activities as a company. And the client says to you, do I need to disclose my plans to expand my business into Africa? And so there's a problem, right? The problem is that this doesn't mean very much. Sure, probably, what the CEO had for lunch does not rise to the level of an essentially extraordinary situation. Unless they ate at like Chipotle last year. I mean, I don't know. You can, right? But most of the time, the easy cases aren't the ones they call the lawyers about. Like everyone knows that you need to disclose a merger. In fact, there's a rule about business combinations, so it's unambiguously clear. But we remember that you would answer your client by starting with an affirmative disclosure. Whoa, this thing got caught. An affirmative disclosure rule. So, you answer the client is not just, well, tell your investors if it's a material fact. You're going to have to start with some statutory or administrative rule that mandates the disclosure of that information. So your client might say, more realistically, we just signed an agreement with a large supplier. Is that a material, definite agreement? You should have the tools today to answer that question. And that probably strikes fear into your hearts because you have no idea what I'm talking about. But remember that we went through Form 8K, Item 101, 102, the disclosure of an entry into a material definitive agreement. The rule specifies exactly what a material definitive agreement is. And it comes down, ultimately, after you apply the definitions to a material right, an agreement that creates a material right or material obligation. You remember that. And so the answer to your client who's asking you, do I need to disclose this new supplier agreement, is going to ultimately, after you do all that basic legal analysis, come down to whether the rights and obligations in that agreement are in fact material. Nod your heads if you're understanding this. This is just the law. Okay? Now here's the problem. You cannot answer your client by talking about the balancing of the indicated probability and at the event that the supplier agreement, I don't know, try to apply this to a supplier agreement. I don't know, is this an essentially extraordinary right created by the supplier agreement that would be reasonably certain to have a substantial effect on our stock price? Who knows? Can we really balance the probability that, in fact, this supplier agreement will, be meaningful to shareholders, and that whatever effect it would have a high magnitude? Like maybe yes, maybe not. I don't know. So some of you came to me yesterday or emailed me kind of like talking about materiality as if it's just this so obviously self-evident test that it's just a requirement. Like it can just be applied to the facts. But it can't, right? I mean, at most you'd have a precedent of a similar case, like most open-ended legal rules, and you would go look at that precedent and you would try to argue similarity or differences. But most of the time, there's always a story that can be told on either side. Now, an important institutional detail that I didn't mention before that I want to emphasize now is that disclosure under the 1933 Act, that is, disclosure pursuant to Form S-1 in the case of an IPO, is subject to SEC review. So before your registration statement is declared effective, the attorneys at the SEC's Division of Corporation Finance will actually read your disclosures. Now, they are unaware of what you do not disclose, but there is a process by which you can ask those lawyers at the Division of Corporation Finance. I did this when I was a young associate. We would write a letter. There's actually a process. One example is a no action letter, where you request, if we were not to disclose the following, could the Commission, the SEC, concur that it will not take any enforcement action on the basis of our non-disclosure of Agreement X. And you would set out in that request the facts, and you would ask the SEC for a determination of materiality effectively for that agreement. So one answer to this question is it doesn't matter, because you'll just ask the SEC and they'll tell you. Unfortunately, that's not a very good answer, because you're not always going to want to ask the SEC. You're not always going to want to answer your client by saying, I don't know, let's go shoot a letter off to Washington, and in 3 months we'll find out. Right? For the most important, mission-critical, business-sensitive disclosure decisions, yes, you will do that. But you young lawyers need to be able to articulate something in this materiality test beyond open-ended nonsense like the probability and magnitude, which can be just manipulated in any setting to come out in any direction you want. The cynical perspective of legal academics. But it is true. When you talk to lawyers, they will often say, it is so clear what is material and what is not until you give them a hard case. And then the answer will be, well, so-and-so court went this way in the past. And that's a fair assessment, and often what we're doing in the practice of law is legal risk prediction. We're saying, what's the chance that a court will hold in one direction or another? And that may have nothing to do with economic theory or anything that you've learned in law school, and is hence often contributes to why you will feel probably that all of this doesn't matter, because at the end of the day, you're just predicting risk for your clients. You're just saying, yeah, if we take this interpretation, courts are probably going to let it go, or the Division of Enforcement, to be more specific here, will let it go. And that's all well and good. But you might, find yourself as a Columbia Law School graduate sitting inside the Division of Corporation Finance. You might be tasked with coming up with a determination of whether an agreement is in fact material, a supplier agreement. You might be tasked with determining whether a disclosure about a cryptocurrency coin should be the basis of an enforcement action or the basis of a rulemaking process. One of my former colleagues, our very own Professor Robert Jackson, who was nominated and confirmed recently as commissioner of the Securities and Exchange Commission, is actively hiring people like you to help him in deciding what sorts of rules should and should not be passed, what sort of information should and should not be disclosed. And this is an active area of policymaking as well. So the fact is that even though often as practicing lawyers, you are engaged in a sort of non-intellectual exercise of risk prediction, sort of saying, look, this just seems to me, it's not completely non-intellectual, but this just seems to me like what courts are going to do. It's also true that one goal of this experience is to give you a framework to think about materiality that goes beyond just the best guess of what the Second Circuit will decide, or the Division of Enforcement. And that may be useful because you have the privilege of crafting the law. It may be useful because you just want to get a good grade in this class. And it may be useful because you actually enjoy thinking about what makes sense at the end of the day, right? And certainly, probability and magnitude are about as meaningless as you can get. It is like literally saying something is material when it's important, right? I mean, if after all, it is important to shareholders and seems important, then we should probably deem it material that is important. It is a complete tautology at the end of the day. So the exercise, why does any of this economic, you're probably so sick of 50% chance of something now, right? It doesn't matter what I say. It's like, oh, I'm tired of 50% chance of anything. So why are we going through this? Because what I'm trying to help you do is understand that there is actually, believe it or not, a logic here. And even though most lawyers aren't trained in economics, and even though you're often just sort of making these gut decisions that are completely untethered from market incentives or what people are actually doing on the trading and business side, you in fact can bring this knowledge with you. You may use it more or less in practice. So what knowledge am I talking about? Well, materiality, we said, is really this. It's an open-ended, meaningless term. So what should we use it for? Well, we should use it, I've suggested, in a normative way. That is, we decide what is material. How do we decide what is material? Well, let's start with the concerns of the dissent, and the majority in Texas Gulf. The dissent is saying, why should we put every company on loudspeaker? The dissent is concerned about a definition of materiality a bar that's so low that everything that's happening in a company is getting disclosed. Now, the starting point for thinking about what materiality should mean is to answer the question why that's bad. Why is it bad to just put the company on loudspeaker and tell the world everything that's happening inside the company? Now, it's very hard to answer that question without some kind of theoretical framework, ask the average lawyer, what's wrong with disclosure? And you will hear nothing. Nothing's wrong with disclosure. More information is always better. That's because most people aren't thinking the way that we're thinking here, which is carefully and critically about inferences, about assumptions that market participants draw when they see or do not see information. And that's the key. The key is to think carefully and critically about what market participants are inferring. And so I just want to walk us through yet one more time the numbers, not because you need to know these numbers necessarily, although it might be a good idea. Let's see if I can switch this over. But because this is a framework that allows you to talk about materiality, there we go, in an intelligent and informed way, okay? So, where did I put this? Okay. So I just want to remind you that any disclosure of any fact can do there's sort of two questions we're going to ask, okay? Any disclosure of any kind can you can do two things, right? The first thing it can do is either increase or decrease our fundamental uncertainty about value. And the second question you want to ask what disclosure might do, disclosure of a particular fact might do, is reallocate profits from informed. I'm going to put trading in quotes, and I'm going to say, or listening, and we'll just reiterate what that distinction means. But these are the two questions. So you get a disclosure, your material contract. The way to think about materiality, listen carefully. If you've never encountered this kind of normative analysis, might be the first time, but I have a feeling you probably have in other classes. When the law leaves us with an open-ended, meaningless standard, what do? We think about policy goals. We think about what we're trying to accomplish, right? This goes back to the first year. And we say, if we interpret it in a particular way, do we further that policy goal? The Supreme Court does this all the time. Nod your heads if this sounds familiar to you at that level, okay? So here, the policy goals we're trying to further with the materiality standard is the following. Would the disclosure of this fact, this supplier agreement, you name it, increase or decrease fundamental uncertainty about the value of the firm? And would the disclosure of this fact, the supplier agreement, reallocate profits from informed trading or listening? Well, let me say again, the normative question is, would deciding that the disclosure of this agreement is mandatory, because we've decided that the agreement is material, or the rights and obligations are material, would that accomplish the goals implied by these questions? A, decreasing fundamental uncertainty about the value of the firm, and B, reallocating the profits from informed trading in a way that's socially beneficial. So we want disclosure to decrease fundamental uncertainty, and we want profits from informed trading to be reallocated in a way that's socially beneficial. Now that's going to vary depending on the setting. So, and we'll talk again about like what an exam answer looks like here, but just analysis, good analysis, is going to come down to whether you can articulate these rationales clearly in the facts that you're given. It's not enough to talk in the abstract. Some of you have sent me emails saying all this stuff in a very abstract, like very general terms. And that's fine. That's going to get you like a B+, right? But if you want to really do well, you got to understand what we're talking about and show how a particular set of facts advances these rationales. So you're looking at a customer-supplier agreement. You know that that's required to be disclosed under Form 8K. I'll reiterate this again when we talk about an exam answer, but you don't need to know all of the Form 8K and SK rules. I'll give you an SK rule. And so you'll see in front of you that there's a Reg SK rule that you have to disclose material, customer, and supplier agreements. Now you're going to ask, what is a material supplier agreement? You're going to have a fact pattern in front of you. Well, you're going to have to decide whether the facts of that agreement should be considered material. That's the point, right? Because materiality has no inherent normative content. It's just literally an open-ended, meaningless standard. But these policy goals are very clear. They do have content. And so you argue that, in fact, we want to set materiality such that we accomplish these goals, meaning, would disclosure of the supplier agreement decrease fundamental uncertainty about the value of the firm? And would it reallocate profits from informed trading in a way that's socially beneficial or normatively desirable, right? That we like. Now, to get more specific, you have to look at some facts, and we're going to do that with cybersecurity disclosure in just a minute. But that's the framework. That's the outline to the answer. Is this? Nod your heads if this is clear. Okay. Now, just to bring it home, if your answer is yes, disclosing this supplier agreement, requiring disclosure of this supplier agreement would decrease fundamental uncertainty about value and reallocate profits from informed trading in a way that's socially desirable, then what? Then we as policymakers, or we as a court not knowing what it should do in the face of an uncertain legal standard, should find that the agreement is material. The law is a tool to further policy goals. This is American legal realism, but it's also just truth, okay? The law has a certain sort of fixed content, right? But at the end of the day, it all comes down to this meaningless nonsense inherent. Like, it doesn't, because why? Because judges, you've heard, I'm not the first person to tell you this, judges like political power, and these open-ended, unclear standards gives them political power, right? Like, come on, this isn't the first time you've heard this. So, try to burst your bubble here, right? So rather than just letting 3 judges decide that they think that mineral content is material because it's just so clear that shareholders cared about it, clear ex post, by the way, that shareholders cared about it, we're going to try to constrain the judiciary, right? We're going to try in our exam answers or in our analysis of the problem to give a reasonable basis for finding that a fact is material. And that reasonable basis is going to be these 2 tests, at least to begin with. Maybe you'll think of more, and that's great. But this is to start with, okay? Nod your heads if this is clear. So you got to articulate. Yes, sir?
Sorry, just to be completely clear,
yes.
Is this like an and or an or? Like, do both have to be satisfied or just one?
So, great question. So, Reginald? Reggie. So Reggie asks, do they both have to be satisfied for something to be material? Think about it like the stronger you can make the case on both of these grounds, the stronger your case for materiality. So there's no, at the end of the day, there is no bright line, right? So it's not that like, let me prove to you that with absolute certainty will reduce fundamental uncertainty. I know that's a little, okay? Like, I can't prove number 1, and I can't prove number 2. I'm going to argue on the basis of the best evidence that I have that these 2, in fact, would be fulfilled. And having done that, I hope to convince you, policymaker, that finding materiality here, that finding that the fact is material, would be, in fact, a good thing for investors. But it is still a gray area determination, and so you have to argue it. And if you want the A on the exam, you'll argue the other side too, right? You know this. On the one hand, on the other hand, and it really doesn't matter which way you come out. Come on, I'm not the first person to tell you this. Okay, yes, Mariah. Great question. So Mariah asks, is this in addition to or in lieu of the probability magnitude test is the law. But you'll always be able to take it either way. So if I were writing the exam answer, and we're going to do a practice question, and you'll see how to do this. It's just like, take Texas Gulf, okay? Copper, zinc, whatever the minerals were here. On the one hand, it seems that the discovery of the core implies a high probability that there will be a incredibly valuable mine. And as a result, and that would have a high magnitude of value increase for the firm or something like that, right? You'll write it better. On the other hand, maybe as the dean said in the expert testimony, discovering like the pool doesn't lead you to the whole mine, or the core doesn't lead you to the whole mine, or right? And so maybe the probability of any further finding is really low. In fact, we don't really know. That's the problem. The probability could be high. The probability could be low. And you'd want to articulate that with the facts. That will always be the case, right? I mean, because if it weren't, it would be too trivial. And you wouldn't even be asked the question or even asked for your advice as a lawyer, right? But you want to articulate why the probability magnitude is, in fact, ambiguous. And that's not hard. It generally is clearly ambiguous. And as a result, we need to look to something beyond the inherent guidance provided to us by the probability magnitude test, because there is none. And that's where you would turn to this framework, where you would say, look, what are the goals of mandatory disclosure? Let's remember that what we're trying to do with securities regulation is benefit investors by reducing risk. That means we want to decrease fundamental uncertainty. Okay, reallocate the profits from informed trading. Remember, we want this all to be kind of macro-cyclical. Don't forget that piece. Okay, so the policy analysis is something you go to when you have applied the law and concluded, like most lawyers do, that good legal questions are hard and thus have no clear answer. And thus, so I apologize if I didn't make this clear earlier. I thought this sort of 1L stuff, but let's make sure we're all caught up here, because maybe you had better or worse 1L professors. So let's make sure we're all on the same page. So the law doesn't take you to any clear answer in the hard cases. That's why they're hard. The question is, what do you use to guide you? You can use a sort of predictive precedent, but that's not very interesting, because that is inherently dependent on what courts do, and they just change their minds. And also, if you're a clerk and the judge wants to know what the right thing to do here, you can't just say, well, do what the Third Circuit did, right? You need to guide your judge if you're a clerk, okay, et cetera. Yes. Abe, right? Yeah. Great. So Abe asks, is there a degree? Well, this is like Reggie's question. The more it decreases, the more you can articulate a reason, an argument, as to why this would really pin down the value of a project, the stronger your case for materiality. The real challenge, and we'll look at this in the cybersecurity example, is that it's not always clear whether a particular fact increases or decreases fundamental uncertainty about value. And that's the problem. That's the Texas Gulf dissent. If you put the firm on loudspeaker, not everything said leads us to the truth. Okay, think about like fake news. I'm like jumping like free association here. Okay, we're in okay. Think like more information doesn't always equal agreement or consensus. So if you put the firm on loudspeaker, if you have Omarosa Big Brother camera going, for those who read the news, 24/7, and you hear the CEO whispering to the, okay, does that actually reduce your uncertainty about what the firm is worth or not? And many times, particularly when we're talking about facts that aren't clear to the market as a whole, that could be interpreted any which way. Think, for example, about cancer research. So a study comes out that finds some progress in a clinical trial. Does that mean that you're more certain about what the firm is worth? Does that mean that the firm is worth more or less? Not even clear, because often safety and effectiveness are negatively linked. So if a drug is effective, it might just kill everyone in the trial. And this happens all the time. So the question of whether fundamental uncertainty is increased or decreased is a tough one. And sometimes you'll have some facts there to guide you. Sometimes you have to think hard about it. But that's what the Texas Gulf Court's concerned about. Otherwise, if all disclosure just reduces uncertainty, let's just full transparency all the way. In fact, one of the hardest policy questions, just stepping aside from securities law, think about even like transparency in administrative law or government transparency. why don't we just make everything transparent? Because people make mistakes, right? People reach wrong conclusions sometimes. And that's the problem. The problem with transparency in general is that more transparency is not always better when better is measured by sort of reaching a consensus. Sometimes you got to filter out the meaningless noise, or you have to choose the salient facts, or people get distracted by the irrelevant stuff. And sometimes they get so distracted by the irrelevant stuff, they never make it back to what matters. Yes. Sam?
Yeah. So I understand going to these policy questions if it's ambiguous, but I guess what I'm wondering about are other policy concerns that might actually weigh against or in favor of materiality, even if they weigh against disclosure. So one example would be if a firm is mandated to disclose a lot about R&D that might be sort of groundbreaking R&D, then other people in the industry might get onto that, and that might in the future disincentivize that sort of research. And so that would be a negative. And so that would, if the research is really important, that would make it seem like it's more material. So it's sort of like that's cutting against the materiality standard.
Right. So Sam asks, what about like competitively sensitive disclosure? Great point. It shows that you read Merritt Fox's sort of overall wide mandate disclosure because he talks there about competitively sensitive information. But just to reiterate, here we are evaluating the application of a legal standard that would apply to all firms. So if you penalize one firm vis-a-vis its competitors, you should be penalizing all firms in the same way by interpreting the law in this fashion. So just so this point is clear, Microsoft may not want to disclose something about its operations that would give Google an advantage. But here we're asking, should Microsoft, Google, and Apple, and all tech firms be forced to disclose fact X about their operations? There's nothing socially wrong, so to speak, with reducing all the profits in the tech sector by a certain amount if you're benefiting investors. Like, that is a pure transfer from the firm's profitability to investors who don't overpay or underpay as a result. Whether or not those kinds of transfers from the bottom line of a firm to the pockets of investors, uninformed investors, remember, whether or not that's a good idea to reduce risk is a question that, remember, we answered by pointing to consumption. And we said it's not always the case that investors are better off when you reduce underpayment, overpayment risk. So I would agree with you that there could be an argument that, particularly for non-macro sensitive risk, that we cannot forget that just risk reduction in general is not always normatively desirable. But you got to articulate that argument very clearly, right? That it's not just because you're hurting one company by giving out competitively sensitive information. There's a very specific story, right, for that to make sense. You are hurting the entire industry. You think that could have some negative effect on like socially beneficial R&D across the entire industry. And the benefits to investors by reducing fundamental uncertainty are minimal, particularly when that fundamental uncertainty is reduced in a way that's non-macro cyclical. Because if it's non-macro, if it's not pro-cyclical, then it's like coin flips. So don't forget the broader framework of whether risk reduction matters. But I want to keep you here on materiality to understand that those general questions are always the case. You may not always have facts where you can articulate like whether something is macro-cyclical or not, or whether, in fact, it's going to hurt the industry. But you're right, Sam, in the broader conversation, we can't forget why we want to reduce overpayment or underpayment risk in general. Does that address your question? Do you have a follow-up? Go ahead.
Yeah, sorry. So that makes perfect sense.
Right.
I guess what I was wondering about in this specific context, so in the context of materiality, it seems that we would not want to make that sort of disclosure if it's not socially beneficial, if it decreases the incentive for R&D across the industry, right? But that would actually seem to make it, like in the specific fact pattern, it would make it more material if this was really important R&D that firms were doing, and thus could have a larger impact on firm value.
Exactly. That's exactly right. So those cut in opposite directions. And if you were analyzing this problem, you would say, on the one hand, we would be really hesitant about concluding that R&D of this kind is material for the following reasons. It's not clear that it would hurt the industry. It's not clear that there's a real gains to investors. On the other hand, out of all the possible R&D that might be disclosed, this one might matter a lot. This one matters a lot. And so, you know, that's a reason weighing in favor. But in the end, I don't think it's okay. The point in terms of both for the exam and also if you're doing this in practice, it's not necessarily as relevant what you think wins in the end, but that you can articulate each of these rationales clearly and convincingly on each side. Okay? Yes. Tell me your name. Yes. Xander. Oh, there you are. Yeah. Yeah, so let's work through a couple examples. And if we run out of time to fully bake the cookie today, we'll bake it some more tomorrow. So let's start with the first one. I want to address, before I get to the second one, let's go through these to answer your question. I just want to go through it systematically. I want to address, before then, a distinction that also came up in emails, and I think some of you are confused, so let's make sure this point is really clear. Fundamental value versus expected value. This is like the battle of two words that, okay, so remember, so I'm just going to lay out this example, and for the mathiverse in the room, I'm very sorry, but just hang in there, okay? So remember, we said the no disclosure world, we're going to look just very quickly at this. Always we have 50% noise traders, always, okay? So we said in this no disclosure world, remember the firm can be worth, we said $9, 50% probability. I know like you're going to vomit after this, okay. $11, 50% probability, okay. And we said what's the price you can buy from a dealer? Does someone remember? What's the price you can buy a share of the company from a dealer? $10.50. Good. $10.50. What's the price you can sell to a dealer? $9.50. Great. Okay. Remember, 50% chance you're facing a noise trader valued at 10.50. Okay, if you need to look again at your first week notes. Okay. So with disclosure, we said the firm is worth $9.50 with a 50% probability and $10.50 with a 50% probability. What's the price to buy? Who remembers from last week, from Thursday? Come on, someone remembers. Let's work through the math. Simple math. 50% chance if you want to buy. So you want to buy. I'll make you a deal. There's a 50% chance. That's supposed to say if you want to, but anyway, forget it. Okay. So 50% chance that the firm is worth $9.50. So 50% times $9.50. How do you multiply percents? 0.5. Come on, guys. I know like a lot of you are math averse, but this is like, you know, if you took like Eric Talley or Ed Morrison's class, like you'd have like algebra and stuff. Like this is like weighted averages. We can do this, okay? So here we go. So 0.5 times 950. Sorry, why did I say 950? If you want to buy, I think it must be because you know something good about the firm, so that's 1050. Okay, so if you want to buy, I assume that there's a 50% chance that you're an informed trader. That means if you're an informed trader, that you have good information about the firm. If you have good information, that means you're in this world where the firm is worth 1050. Okay? In that case, it's 100% likely. That's why it's 1050 here. Because if you are going to buy, then I assume you must have good information. So that's happening with 50% probability. So there's a 50% chance that I'm facing an informed trader who knows with certainty that the firm is worth 1050. There's a 50% chance that I'm facing an uninformed trader, a noise trader, who's just buying for the fun of it. In that case, I assume the firm is worth 10. This will be on the exam, so just make sure you know this, okay? This setup. Just the numbers will be different. It'll be the same problem, so just make sure this is clear, okay? 0.5, okay? Averaging, just averaging, 10, 50, and 10. What's the answer? 10.25, right? Okay. By the same logic, if you want to sell to me, it's the exact same math. I assume you must have bad information with 50% probability because there's a 50% chance that you are informed, plus 50% that you're a noise trader, 975. Okay, so those are the prices. No disclosure, you can buy at 1050. No disclosure, you can sell at 950. With disclosure, you can buy at 1025. With disclosure, you can sell at 975. Now, we said last week that disclosure moves prices closer to their expected value. You see that, right? What's the expected value? 10, right? Expected value is just the average weighted by the probabilities. It's just a weighted average. So, if there's a 50% chance of 950 and a 50% chance of 1050, you add them up, multiplying by 50, you just go through this exercise, 50% times 950 plus 50% times 1050, and you get an average of 10. Whenever you see expected value, just replace it with average. All right? So the expected value is 10. You can see that as between these two worlds of 1050 and 950 versus 1025 and 975, which one's closer to 10? No disclosure. I know it's a large class, but which world has prices closer to their expected value? Disclosure. Great. Now here's the question. Is the firm ever worth $10? Does anyone, I want to make this easy. Who thinks the firm is never worth $10? Okay. Those of you who did not lift up your hands, do you think the firm is ever worth $10? Well, we just said there's a 50% chance it's worth 9, a 50% chance it's worth 11 in the world without disclosure. In the world with disclosure, there's a 50% chance it's worth 950 and a 50% chance it's worth 1050. And no matter how many times I say there's a 50% chance, it's never worth $10. Does everyone understand this? Nod your heads. This is crucial. Okay, this is like eating the vegetables. You just got to get this, okay? It's never worth $10, ever. So prices are closer to the expected value, but the firm is never worth the expected value. What is the expected value? It's the best guess of the firm's value. Actually, it's the least informed guess you can possibly make. It's neither optimistic nor pessimistic. It's exactly indifferent about whether there's a good or bad day for that company. Nod your heads if this is clear. So the expected value is not equals fundamental value. The fundamental value is either 9 or 11 in the world without disclosure, or 950 and 1050 in the world with disclosure. Okay. Now here's the point. Disclosure still reduces mispricing. Disclosure reduces mispricing, what I've called reduces overpayment, underpayment. Not because it's closer to 10, though. So this is, yes, but not directly. Okay, so let's just work this out so this is clear. It reduces overpayment and underpayment. Why? Well, what's the overpayment? Let's walk through the overpayment and the underpayment. I want to make sure this is totally baked and crystal clear. So what is overpayment and underpayment? So just think, if you want, about the noise trader who buys what? Well, let's start with the no disclosure case. Now I'm going to try to make this extremely clear. What is overpayment? Let's just focus on overpayment. No disclosure. You buy a company worth $9 for how much? Now I'm going to pause until someone answers. Good. $10.50. Or you sell a company worth $11 for $9.50. It's really not hard. So you overpay. How much? By how much do you overpay? Each time. I'm just going to wait. Yes, $1.50. Here we go. Come on. This isn't hard, right? Okay. Now watch. What happens with disclosure? You buy a company worth how much? How much is the fundamental value in the disclosure world? Great, $9.50, excellent. For how much do you pay to buy in the disclosure world? $10.25. Remember, this is how much you pay, $10.25. Here, if you buy, $10.25. Okay, you might sell a company worth, what is it worth in the good state, in the good state of the world and the disclosure regime? $10.50, here we go. Exactly. For, how much can you sell a share of stock for? $9.75. You guys are getting it. Here we go, right? By how much? I write this so you can do the math. By how much, I'm writing, do you overpay? 75 cents, right? Does anyone disagree? No, okay. Which is greater, 150 or 75 cents? $1.50 or 75 cents? Which is greater? Great, $1.50. Here we go. We're on our way. All right, guys. So you see this, right? So in the disclosure world, you overpay by less. But it's not because $10 is somehow the true value of the firm. It's because of this right here. It's because you overpay by 75 cents. That is related to the fact that the range of values has shrunk, but it is not because, strictly speaking, we're close to 10. I mean, it kind of is. Anyway, you can argue that point, right? Kind of is. But not because 10 is the value of the firm. I want to correct that mistaken conception. Okay, nod your heads if this is clear. Now, more advanced question. What I just described is like what happens to noise traders. They overpay. You are like a noise trader, especially if you bought Bitcoin a few months ago. So we know that the savings accrues to noise trader. Who were these savings taken from as a result of disclosure? Michael. Exactly. Form traders. Disclosure just literally, like what disclosure does. Disclosure just, you have informed traders. What's an informed? My wife says you cannot draw. Okay. It just gives their money No, I guess noise should be on the bottom. Let's do this correctly. Noise, traders, oh, they have smile faces, they're happy. Okay, we got this. Everyone sees this. All right, now we'll take the drawings off the board. Okay. Now, I want to make sure this point is clear. Disclosure just transfers money from informed traders to noise traders. Now, it can have other effects. As Sam pointed out, there can be first-order, real-world effects, and I'm not saying there aren't. But I want you to understand the economics here. It's very simple. By reducing uncertainty, you take away profits from informed traders. Now, this goes to the question about why we care about how much profit informed traders have. So, disclosure kills in profits to informed trading, hands them to noise traders, because everyone now knows with greater certainty what the firm is worth. Is that a good thing? Well, it depends on the story you can tell about why you want or don't want informed trading. What's a setting we discussed in the context of the 1933 Act? Here's a hint. IPOs, where we talked about informed trading that's actually sanctioned by the law to some extent. There's a very particular setting we discussed where the law allows for some investors to get some information about a company who's about to IPO. Yes, in the back? The roadshow. The roadshow is a what? Non-disclosure event. Does everyone understand this? You cannot actually tell the world what happens at a roadshow. But the way to think about it is a legally sanctioned period of don't tell anyone what is going on here. That hands money to informed traders, specifically those banks and others who are at the roadshow. Now, is that a good idea? This is the question. So remember the policy question here that you ask. A, does a particular fact increase or decrease fundamental uncertainty? It should decrease it if it's the kind of thing we want to disclose. B, does it reallocate the profits from informed trading or listening? We'll talk about that in 30 seconds here. In a way that we think is socially beneficial. Well, in the case of the roadshow, why might it be socially beneficial to give some investors an advantage? Well, we said because it can be kind of hard to figure out what a new company is worth. The idea that it can be a good idea to give some investors an advantage in figuring out what a company is worth is often justified when there's some information that's hard for the general public to figure out. So, to go back to Reggie and Abe's question, you might even not think of these two as separate tests. You might think of them as kind of intertwined. You might ask, if I require this information to be put out there, if I decide that it's material, what I'm doing is I'm taking money away from informed traders. Now, those informed traders might be precisely the kind of market participants who are good at figuring out what the text means, what the actual information itself means for the value of the firm, thereby telling the market as a whole what the value implication of that information is, and reducing fundamental uncertainty. So if I don't have informed trading, sometimes it might be the case that there's greater fundamental uncertainty. An example might be cancer research. If I allow the doctors who are reading the abstracts, these can be even public abstracts, if we allow them to trade on the basis of their better skilled interpretation of those abstracts, that puts money in their pocket. To realize their profits, they will probably tell the world, this is a great cancer company, the one I've bought, and this one isn't. Now, before you say, well, that seems really shady, who else is going to do it? Who else understands whether a clinical trial actually means a drug is on the way? That's going to work. So it could be that by giving some investors profit, you subsidize the translation of text that nobody understands to value implications in a way that reduces fundamental uncertainty. So by deciding that a particular fact is not material and thus not subject to disclosure, you could accomplish 1 and 2 at the same time. Right? You can give profits from informed trading to those who will be likely to decrease fundamental uncertainty. It could also be the case that that doesn't happen. So, who read my paper with Eric Talley on cybersecurity disclosure? Nod your heads if you saw it, at least. So who remembers the story of Muddy Waters and St. Jude? Nod your heads if you saw this in the introduction, if you glanced at it at least. So what inspired this project was a New York Times article about a short seller, Muddy Waters. Carson Block is the head of it. And they produced a research report finding that St. Jude, which was at the time a publicly traded pacemaker manufacturer, that their pacemakers had a cybersecurity vulnerability. You could stand on that side of the room and zap someone and kill them by hacking their pacemaker. And Muddy Waters, the short seller, made a deal. Well, how they found this out was they made a deal with this company, MedSec, which was a sort of white hat hacking private securities firm. And they said, look, go out and find, they said to MedSec, go out and find a bunch of medical device manufacturers. Tell us which ones have holes in their bugs, unpatched vulnerabilities that are amenable to hacking. Let us know. We'll short the stock. We'll sell those companies before you tell the world. We'll split any profits with you. And then we'll announce that we found this pacemaker, these pacemakers can kill you. And that's exactly what they did. And they made a lot of money on that announcement, both the short sellers and the medical security researchers. Should disclosure of St. Jude's pacemaker vulnerability, suppose, for the hypothetical at least, that St. Jude knew of this vulnerability but was keeping it quiet? Volunteer. Should that be considered material information? You know, let's say we're in some part of the registration statement, materiality is an issue, you've spotted the issue, and we're now talking about you've done the probability magnitude test, and now you are trying to figure out, should we require the disclosure of known cybersecurity vulnerabilities that are known by the firm? Someone volunteer? Yes. Christian. Apply the test here. Go ahead, yeah.
It seems like, I would say it was material, but applying our two questions here, it seems like it would increase your understanding about the fundamental value of the firm, but who's going to do that kind of research if we don't allow some sort of informed trading profit from it?
Good. So Christian's answer is a good answer. It's like probably an A-minus answer. It's a good answer. What would take it further? I mean, why is it already a very good answer? Because he applied the test, okay, and he articulated, particularly for number 2, a reason why we might want to allow companies like MedSec to keep some profits from their informed trading, from the deals they strike with Carson Blocks of the world, with Muddy Waters of the world. Carson Block's the head of Muddy Waters. So, the thing that's sort of missing from your answers, so just to give you feedback for this, is just what do you want to say? Why is it that it might decrease or increase fundamental value? In other words, you want to also articulate a reason for number 1, right? So you just said, this is what it seems to me. I'm just putting you on the spot. It was a good, well done. But just so everyone understands, you said, it seems to me, but why? Well, you want to try to articulate a reason. So you might say, look, you know, the technical meaning of a vulnerability is often very hard for the public to understand. I mean, do you really know when you see an announcement about a potential exploit, whether, like, how serious of a risk that poses for the company? You might say, well, of course, Josh, any potential exploit reduces uncertainty. Now I know more about the company. I know it has another vulnerability. But always think, I'm getting new information relative to what I already knew. So I know that Microsoft products have a lot of vulnerabilities. That's already baked into my 50% worth X, 50% worth Y calculation. Whatever I think the value of Microsoft is baked in. Whatever I thought the value of St. Jude is, there should be some cybersecurity risk already baked into the price. So the question is, would disclosure of this kind of vulnerability, the pacemaker shock lethally kills you from across the room vulnerability, help me pin down better what St. Jude is worth? Now, what's interesting about this case, maybe if you read the paper you saw this, or I think maybe it was in the footnotes we cited, St. Jude vigorously disputed that. They disputed the meaning of the vulnerability for the value of their firm. What they said is, this is exactly the kind of thing that can be routinely discovered in any piece of any medical device. It's not practical. All you're doing is whipping the public up into hysteria so you can spike the stock down and profit and walk off. That's all you're doing. It's just mass hysteria. And in any event, if there was a real problem, you would come talk to us about it rather than publicizing it. But putting the last part aside, which is kind of another interesting question, think about the claim that, in fact, publicizing the vulnerability there was not necessarily going to help investors pin down the value of St. Jude. Why? Because sometimes these vulnerabilities actually are very hard to exploit, and all you're doing is inducing fear and hysteria. So, and the A answer, just to pick on Christian, but that was great, the A answer would articulate that rationale, right? So you want to articulate a reason, and ideally on both sides of the issue, as to why there would be more or less fundamental uncertainty, and I just did it for you in the pacemaker example. On the one hand, that's exactly the kind of thing that can be very value determinative for a company like St. Jude, can make or break the company's future. Obviously, if thousands of pacemaker patients are electroshocked from across the room, that would be the end of St. Jude. On the other hand, this is exactly the kind of thing that can induce hysteria and not clearly guide investors as to what the company is worth. That's the exam answer. Does everyone see that? I'm just making sure no one says to me in May, why didn't you make this clear? It's clear, I hope, right? That's the analysis, okay? Everyone is with me? So what do we do in the study? Brief advertisement for the study. Law review editors out there. We basically looked at corporate data breaches. And we said, if you look at corporate data breaches, which are disclosed, have to be disclosed by law, you can actually measure, not at the time when the company knew about the breach, but you can go back in time to a point when only the hacker could have known about the breach, and you can see as they're trading on the basis of the knowledge of the successful hack, long before anyone at the company even knew they were hacked. So what this paper is about is kind of not even really a disclosure, insider trading, or anything having to do with the material we're learning in this class. But I think it's kind of cool. Because what it asks is, can you make money as the hacker trading, that is, accumulating a position in the stock before even any insider finds out, because you know, and only you, that you have successfully exploited a breach and obtained some sensitive personal information about the customers of this firm. We find that happens systematically if you look at put options, which are a kind of way to trade on information. And in fact, what we talk about in the last part of the paper is that it's not clear there's anything illegal about that. Now, you might be equipped today to ask normatively whether it should be illegal, because you could take these tools, which we've talked about in terms of I need to correct what I said. It's not that this setting has nothing to do with what we're learning. It's that the law, securities law, does not encompass settings like these, where the information is created and obtained by a party completely external to the firm. Our conversations thus far have involved disclosure mandates that apply to the firm. That's Reg SK. We're going to talk about insider trading law. This paper is really about insider trading law, which does not extend to trading by someone like the hacker in this story. The hacker is not an insider. We're going to learn this. Doesn't owe any duty of confidentiality to the firm. The hacker has actually penetrated the systems and found the vulnerability or created the vulnerability themselves. That puts them outside the reach of insider trading law, which you'll understand later in the semester. And it's kind of an interesting question whether computer fraud or computer crime law would actually prohibit the gains from trading. There might be a question around collusion, conspiracy. If the hacker were to conspire, like in the MedSec hypo, perhaps you loop in the trader on a conspiracy-based theory of liability for the hack. But if the hacker were to sell the obtained information to a trader in an arm's length open market transaction, this is not on the exam, don't stress, just fun thought at the end of class. If the hacker were to sell the information in an arm's length deal, you might think that would be illegal, but actually there should be no prohibition. As far as we know, there's no prohibition on trading on information that you obtained, so long as you had no basis to know that it was obtained in breach of some duty of confidentiality. We'll talk about tippers and tippies when we get to insider trading. And this is kind of interesting because here you could imagine hackers putting the information for sale, and who buys it? Hedge funds who are going to trade on it 100% lawfully. And we're pretty sure that it's 100% lawful. Yes? Yes. Yes. Sure. So the question is, should we be worried about the cost of disclosure? Yes. Is it very costly to put out a press release in the Texas Gulf case that you found these minerals? Do you think it is? I mean, that's an empirical question, right? It could be. For some disclosures, yeah, I think you're absolutely right. It could be. A lot of times, we're talking here about qualitative disclosure. So a lot of these are like, we were hacked. Now, is that really? I'm just keeping it in the cyber example. I mean, is that incredibly costly? I don't know. What's costly is if your investors misread it. So I'm going to keep the conversation there because that's really the concern in Texas Gulf. The dissent makes that clear. And that's the policy concern. I mean, the cost of getting the lawyer to read the press release, that strikes me as marginal. Maybe for some disclosures it's not. Small companies have complained about accounting burdens in particular. But here, I just want to keep it in the course material. We're focusing on Reg SK, qualitative disclosures, information like cybersecurity vulnerabilities, right? Other questions? Yes, Abir.
I had a question regarding your response to Sam's question earlier in the class, shifting from a firm-specific perspective to an industry-specific or an economy-specific perspective.
Yes.
So when you get a question about, if you're presented a fact pattern about a particular client, or if you're a lawyer and a particular corporate client comes to seek our advice regarding whether it should disclose some piece of information, whether it's material or not, are you saying that whether, to answer that question, we shouldn't really think about the client situation, but whether that particular piece of information is also going to be relevant to other people in the industry or the economy? So we actually don't really think about the client, but the impact of that disclosure and whether that disclosing that information will be relevant to other people in the industry?
So Abir asks, can we I reinterpret your question, can we turn this into a subjective inquiry? Can we look at if you're asked to opine, can we say, well, for this company, it may be value reducing, but for other companies it wouldn't necessarily, or can we use facts about this company? Remember that we like the law here to be somewhat general. I mean, there is a gray area here, right? So it could very well be that you can bring in circumstances that are unique to that company and say, look, you know, this would or wouldn't be value reducing in these settings. I kind of did that with the St. Jude's example. You know, it turns out that these particular vulnerabilities, it's hard to know what they mean. But there might be other vulnerabilities that we can really learn from. The broader question about what you might do, the posture I want you to be thinking of is, you know, if you interpret materiality, if you interpret a particular contract as being an MDA, a material definitive agreement, that interpretation is going to apply to more than one firm. So even the securities lawyer isn't going to go very far by arguing that it really didn't matter to our shareholders. Like, if you were to ask them, if you were to conduct a survey, they would tell you that that's not going to convince a court or a regulator because they're thinking this is a general interpretation question. It's going to apply, other firms are going to ask the same thing, and I'm making a rule that affects the industry as a whole. And this is why, and we're out of time today, but tomorrow we'll go back to the Easterbrook article because I want to open class by going through his discussion of why it is that the 1933 Act did not increase average returns, which is responsive to your question from last week, and I think will illuminate this policy conversation. We'll spend the first 10 to 15 minutes on that, and then we will move away and talk about forward-looking statements. All right, no office hours tomorrow, but next week for sure. See you tomorrow. Yes, sir. Yeah.
Thanks so much for being
No
here.
problem. Pleasure, Robert.
Hi, Regina. So nice to meet you.
So we have the podium mic and the clip-on mic, whichever you prefer.
Okay. I haven't done the clip-on before. Do you guys have a pointer by chance?
Yeah, I think.
Yeah, that'd be
I'm
great.
not sure how.
Does
well
it
people
click
can see.
too?
Yeah, this is for the
Great.
PowerPoint, right?
And yeah, and the PowerPoint we sent ahead of time.
Let me put it up,
Great.
sorry.
Sure, no problem. Oh my gosh. But basically what we've already, gone over. Just some real questions about the liability of the schools now doing the change of status, like touching it. And that's going to be really interesting. Like, this decision David's going to have to make, and I'm not familiar with how much we do. Not at all. And the Jays, do we not either? Do we always say, go see this list of attorneys? Yeah. Now, that's a question. Is it going to be different? So, great.
Is this the one?
That is
Okay.
absolutely perfect. Thank you so much. Sorry. Just make sure. So I'm trying to make sure that it's got the feel of it,
Oh,
and
yeah.
that it doesn't have a.
If it doesn't recognize sometimes, just point it down here because this is where the receivers are.
Oh. Okay. Maybe I'll leave that open.
Yeah, should
I
receive.
think that, that might be a little bit. For some reason, it's taking a hard press.
Yeah.
I'm not sure why. Is there a manual way to? Or is it just not going fast?
Yeah, I
as
think
well?
the back one is just a little hard.
Okay, so now that I know that.
Oh, let me- Sorry.
No problem. Or is it better
Yeah, you have to
do?
press it pretty hard.
You just feel this,
But the right one's working.
the right